Hi, I'm Carl Shusterman. I'm an immigration attorney, and I used to work as a prosecutor for the Immigration Service from 1976 to 1982. And since that time, I had a firm called the Law Offices of Carl Shusterman in downtown Los Angeles. Today I want to talk about one of the forms of relief from deportation. It's called cancellation of removal for non-permanent residents. And there's 4 basic requirements. The first requirement is that you must be continuously physically present in the United States for the last 10 years. Continuous means that you cannot have been out of the U.S. for an aggregate period of over 180 days, and you cannot have any trips out of the United States for 90 days or more. Also, you must be a person of good moral character for that 10 years. To be a person of good moral character is not defined in the immigration law, although they define certain traits that prevent you from being a person of good moral character, mainly criminal convictions. If you do have criminal convictions, depending on how serious they are, you may not be eligible to apply for cancellation of removal. Number 3, criminal convictions again, and security and fraud grounds of inadmissibility from the United States may render you ineligible to apply for cancellation. But the real drama comes in the 4th part, which is that you must be able to prove extraordinary and extremely unusual hardship to certain qualifying relatives. And those relatives can either be your parents, your spouse, or your children, but only if those people are either citizens or permanent residents of the United States. Hardship to you does not count, only hardship to those relatives. And I should mention 2 exceptions. One is, if you're in the military, this video really doesn't apply to you. The period of time, though, for somebody in the military to apply for cancellation of removal is that they be in the United States for 2 continuous years. And there's also exceptions to make it easier for people who are battered spouses to apply for cancellation of removal. But since the main part is proving hardship, let me talk a little bit about that. The law provides that up to 4,000 people can get green cards based on cancellation of removal, but in reality, less than half that number qualify every year because they can't meet the hardship requirement. And the other half of those green cards are essentially thrown in the trash. So what do you have to prove to your qualifying relatives to show that you meet the hardship requirement? Well, of course, almost everybody's going to have the requirement, or going to satisfy the requirement that if they go to their home country, their economic circumstances are going to be worse than they are if they stayed in the U.S. So that itself is not going to win the case for you under hardship. The other thing is family separation. You know, you have to present the case in the alternative. Let's say you're married to a permanent resident and you have 2 kids who are U.S. citizens. You could take those citizens with you to the country that you're from, or you could leave them with your wife in the United States, or you could just take the whole family to that other country. And you have to talk about these things in the alternative. How would the kids suffer? How would your spouse suffer in each of those circumstances? Also, there are things like advanced age. What if you're supporting your parents and they're 80 years old and they're on all sorts of medications and you drive them to their doctor's appointments and so on? That's obviously going to be a great hardship factor if they're citizens or permanent residents. Medical needs in general. If your kid is suffering from some disease that cannot be treated in the country that you're going to, that's definitely a strong hardship factor. And then there's special educational needs. If your child has an educational disability, he or she is retarded, or maybe he or she is a special student who scores very high on test scores and is getting college scholarships, that person may not be able to get the same educational opportunities in his country. The main thing that you have to think about is it's not going to be any one factor that's going to pass the hardship test. The landmark cases that we have to follow that define whether you've met the hardship requirement says that the government has to consider the hardship factors cumulatively, or sometimes they use the word in the aggregate. It means they have to consider them all together. So if you bring up 7 different hardship factors, then if the judge omits 1 or 2 of the important factors, you will have a basis for an appeal. It's impossible to really generalize about these cases. Every case has their own facts. If you go to our webpage at www.shusterman.com and click on deportation near the top of the page, we have a case study of one of the cancellation of removal cases we did. It's about the Cabrera family. They have 5 qualifying relatives, and you can read all our briefs, the judge's decisions, and all the rest of the information about their case, and it'll give you a pretty good idea how to do a hardship presentation for cancellation of removal. Also, we consider cancellation of removal and all the other forms of relief from deportation on our deportation page under the heading How to Avoid Deportation. Thank you. I hope this video has been helpful for you.